Facebook friends. Welcome to the Joint Veterans Endorsement interviews for judicial candidates. On the outset, we would like to thank the formal recognized organizations for making today's event possible: Veterans in Politics International, Nevada Veterans Associations, and Armed Forces Chambers. We also like to extend our sincere appreciation and additional sponsorships and community partners of those who help ensure a professional, fair, and transparent endorsement process. Judge Jacob Reynolds, Department 29, Mary Perry, Department P, Veronica Birch, Department 5, Danielle Tarmu, candidate for Clark County Court Judge, Department 28, and Amanda for Las Vegas Municipal Court, Department 1. Sorry, I don't want to mispronounce her last name. So, Judge, the way this is going to work is each panel member is going to ask you questions. You will have 1 minute to answer the question. When you see my hand goes up, that's 30 seconds. When the hand goes like this, we'll start counting down from 10. Please keep them short. Please don't duck questions and don't use lawyerese. Let the people know who you are and why they should vote for you. The panel members will introduce themselves going around, tell you who we are and what we're for. Every panel member, state your name and your organization before your questions. You will have 1 minute and 30 seconds to tell us who you are after we're done introducing ourselves and, why we should keep you or vote for you. Bill, would you like to start?
Thank you. Bill Carnes. I am with Nevada Veterans Association. Welcome, Judge. According to Article 6 of the Nevada Constitution. Oh, pardon me.
Michael McDonald, VIPI, and CEO of Family Vacation Alliance.
Bradford Carlton, Armed Forces Chamber.
J.P. Edwards, Armed Forces Chamber.
Frank Friends, Veterans in Politics, and Court Observer. Judge, would you like to tell us who you are?
My name is Michele Mercer. Well, Michele is my formal name. I go by Michele Mercer, and I am a judge, district court judge in the Family Division, Department Z, and I am running for re-election. I was elected to the bench in 2020, and so I have been on the bench for about a little over 5 years, and I have been a licensed attorney for 27 years. And the reason I decided to seek the bench in the first place was because I felt like I was led there based on all of my experiences and who I am as a person. I care very much about families and children, and so therefore I wanted to serve them in a bigger and better way. I felt like I could really make a difference, and so that's why I'm here.
According to Article 6 of the Nevada Constitution, describe the vesting of judicial power in the state and the primary courts in which it's established, and how this framework limits the authority of judges to ensure proper separation of powers.
Can you repeat that question?
Yes.
Thank you.
Article 6 of the Nevada Constitution establishes the judicial system in the courts. Can you describe the framework in that, how it established the courts, and how it ensures separation of powers in the state between legislative, executive, and judicial?
Okay. Everything that you just said is grounded, actually started in the United States Constitution. And it actually formed the three branches of the government: executive, legislative, and judicial. The executive branch includes the president, and it is known for enforcing the law. The legislative branch is your legislatures, your assemblymen and women, and they are the ones who actually write the law. Judicial, we interpret the law, and we have people come in front of us and try to establish what their facts are, and apply the law to them. And then through the United States Constitution, then we have the state law, and then Nevada has its own constitution and has the three branches of government. I'm not sure I completely answered your question, and I'm told I'm out of time. Did I answer your question?
You didn't even get close.
I didn't even get close.
It's all right. I'll reframe it next time around.
I'm a teacher by
It's okay.
my nature.
All right, go ahead, Mike.
Hi there, Michael McDonald, VIPI. Thank you for being here today.
Thank you.
I have a question about, so my question's about equality. So when you go to court, there's a preference for mother or father to get the child. There's a new law where it's a preference that both parents have joint custody, but it's not a set standard. So when you go to court, there's a preponderance of the evidence, and then there's a beyond reasonable doubt. Maybe could you explain how you decide and discern what parent should get custody or have that set standard or not? And are you aware of parental alienation and pathogenic parenting? And also, have you watched Divorce Corp, the documentary?
Wow.
Sorry, I know it's long.
Yeah, 60 seconds.
Okay. Wow. Okay. Yeah. Nevada law says that the court cannot prefer one gender to another. So when people walk into my courtroom, they are on equal footing. And the law does tell me that the preference is for joint legal custody, joint physical custody, meaning that both parents have equal rights and equal timeshare with the child. And that's presumed to be in the best interest of the child. That's the way when they walk in the door, that's what I'm already thinking. And then it's up to them to convince me. These are the scales of justice, right? I can see them in my brain, but I know it looks a little weird. But the scales of justice are what I'm constantly thinking of. I have the Lady Liberty right there on my bench, but she's constantly weighing the information to determine the weight of whatever information she's given, whatever weight the court is given to determine any variation from the preference that the legislature instructed me to follow. And so the standard that we follow in family court is the preponderance of the evidence. That just means it's more likely than not that the court should rule this way or that way, like 51% to 49%. It's very slight. It's very slight. Beyond a reasonable doubt is a criminal standard. We don't deal with criminal standard in family court. That's over at the other courthouse. But we're civil most of the time, hopefully. But in family court, yeah, it's beyond, it's preponderance of the evidence. What? In family court. In family court. Did I not say family court? Sorry.
Bradford Carlton, Armed Forces Chamber. So a tactic that I saw happen every now and then when I was an attorney was that a party would make an accusation of domestic abuse, whether or not there was some there, in order to try to gain a little bit of advantage in court. How do you balance the need for protection of potential victims versus the rights of a potential accused?
That is very difficult to do, and we do that often and a lot. And sometimes that is a tactic used by one parent or the other to try to, as you talked about, and I didn't get to answer, parental alienation sometimes. So it's very difficult sometimes to discern one way or the other. Are we talking about true domestic violence? Are we talking about an ongoing pattern of domestic violence? Is this just a situation where all of the stresses of the world combined and somebody just lost it and did not behave very well? And it's hard to discern between amongst all of those things. But I pay very close attention. I look at everything. I look at the application for the temporary protective order, if there is one, if there isn't one. I look at, is there a long history of it? But that doesn't mean that I encourage people to go and make false applications. But starting with knowing that the children need both of their parents. Holy cow, I'm already out of time. I'm normally not long-winded. I just try to be very thorough.
JP Edwards, Armed Forces Chamber. What does the best interest of the child mean to you in practical terms?
In practical terms, it's just simply what's best for the child. And the legislature has instructed me that the sole consideration, the only thing I'm to think of, are the children, when children are involved, the best interest of the children. And the legislature has also given us 12 factors. They include the wishes of the child, if the child's of sufficient age and capacity to form an intelligent preference as to their physical custody. Also, nomination by a parent for guardianship. Also, which parent is more likely to ensure that the other parent is going to have frequent associations and a continuing relationship with the other parent. And also the level of the conflict between the parents, the mental and physical health of the parents, and their ability to cooperate together, and whether or not either has committed domestic violence or abuse and neglect or an act of abduction. And there's a few others as well that I ran out of time.
Okay, so all these judges continuously talk about best interest of the child. So we've had over a quarter century to understand what happens when children go with what parent. 70% of all dropouts, teen pregnancy, drug uses, juvenile delinquencies, or juvenile criminal court, 85% of all criminals, and 279% of all persons who carry a gun and or are caught selling drugs have a 20 times percent chance of ending up in prison, have one factor in common, and that's raised by a single mother. Anytime the children are given physical custody to the father, they have almost statistical outcomes as being raised by two parents. Even though Nevada states that it should be two parents getting it, it's proven that primary custody, statistically in the best interest of the child, should be given to the father until evidentiary is heard later. And armed with this knowledge going forward, how do you feel about the current situation where you guys are still more likely to give custody to the mother, even when that's not in the best interest of the child? I'll give you a minute 30.
I am not known for preferring mothers. I don't prefer mothers, but I don't prefer fathers either. I see them equally. Children, I feel very strongly about this. Children need both of their parents, unless there's a reason for the court to believe that they're not safe in one of the other's homes, or, like I said, the other best interest of the child. Those statistics are fascinating to me. But I took an oath to the Constitution and the Constitution of the United States, the Constitution of Nevada, to follow the law that the legislature has given me. I'm forced to do that. And so that means that the men and women, fathers and mothers, are equal in the courtroom until they've given me some reason to differentiate between that. I've been criticized for giving fathers primary physical custody more than mothers. I don't think it shouldn't be a criticism at all. I think it's just the way the evidence played out in front of me during the evidentiary hearing. But that is a criticism that I have been tacked with, I guess. But no, I think both parents. Here's a perfect example in my personal life. I have two children. And my husband, of course, well, he was a Metro officer retired 29 years, Metro officer. He's really tough, right? He's the disciplinarian. And so sometimes I thought it was too rough. But no, my kids are amazing because we balanced one another. And that's why I think both parents are very important.
Bill Carnes, Nevada Veterans Association. So
I'm sorry, those statistics I can consider like if another factor, if everything else is the same. But anyways, sorry, go ahead.
You mentioned something about the oath that you took. In Nevada, the oath of office is an oath to the Constitution of the United States, the state of Nevada, and its government. Do you see a conflict between having to swear an oath to both the ingredients and the chef when it comes to the Constitution and the government, since one is there to serve the other and one is to bind the other?
I don't know. I think I'd probably use it my minute and a half just contemplating your question.
You seemed very constitutionally savvy on the last question I asked, so.
Sarcasm, right?
No, not at all. No, you're very constitutionally savvy on it.
Oh, thank you. Do I see a conflict? I don't know. I don't feel like I don't have enough information to be able to offer an opinion. I don't like making stuff up. I would prefer to be able to contemplate that some more. Okay. Okay.
You don't have to use all 60 seconds. It's okay.
No, I would. Could you read it again so I can think about it some more? I'm out of time.
No, you won't have. Wasn't even read it. And you can contemplate this, but do you see a conflict in swearing an oath to both the Constitution of the state of Nevada and the Nevada government?
You think they're in conflict with one another?
100%. They have
Okay.
to be. One designs and restrains the other. The other serves and tries to manipulate the other. So there is basically an overseer, which would be the Constitution, and the government, which it has created.
I'd be happy to talk to you about that some more, about where there's obviously a story or two that derives that question.
All right, guys. So we can continue to keep this going. Remember, no follow-up questions. Judge, either you can get it or you can't, or we'll explain it better on our next round.
Okay. Michael McDonald, VIPI. So part of the conflict in family court is an adversarial court process. So you have litigants that have never been involved in family court matters. And there is a conflict between Title 4D, which is the Social Security, and judges' retirements as well. So there's a proclivity of separating children from their parents to fund these judges' retirements funds. Are you aware of that? And what would you do to follow the canons and improve family court so that people have joint custody and are able to be in their children's lives, as a lot of them get separated due to false allegations of abuse?
My goodness, you've asked for a dissertation.
1 minute 30.
Oh my. I'll start with your first question, whether or not there's a conflict between the Social Security and I believe you're referring to PERS, that's the retirement for judicial officers and police officers, state employees. Is that right? Is that what you're talking about? You're saying that there's a conflict between them. We don't collect both. We get one or the other.
Sorry.
And then the second half of your question, I was still thinking about that, the first part when you're to improve family court, which more funding, more education for people who aren't, they don't have the ability perhaps to retain counsel. We have a wonderful self-help center, but some means of being able to educate people, treat people, teach people how to navigate the process. I think the problem exists even before that. I think people need to learn better how to communicate between one another, because often we say things that we don't mean and they escalate because we haven't learned good positive communication skills. That's what lands us in family court in the first place.
Bradford Carlson, Armed Forces Chamber. I feel like I'm giving you softballs over here compared to these guys. So
it's okay.
We know that legal services are expensive.
Yes.
I mean, I used to be an attorney, and I don't even know if I could afford an attorney.
I know that I couldn't afford one.
Given that fact, how would you be able to handle, or how do you handle pro se self-represented litigants who may not understand court procedure, who may not understand what exactly they need to file, may not understand where to stand in the court?
Yes, this is a area of conflict for me a little bit because I am a teacher, and when people ask me questions, I tend to start at, down at the very, like, okay, this is where you start. Instead of, if you were to ask me, what's the alphabet? I wouldn't start at the letter M and say, okay, there's an M and there's a G and then there's an A. I would start at the very beginning to explain what the alphabet is. That's my nature because I love teaching. And so I'm very good actually about self-represented litigants coming into my courtroom and trying to you have to maintain a balance. Everything in the law is a balance, just about. Maintain a balance between over helping them, because I don't want to be perceived as helping this person more than helping this person, like I'm favoring this person over that person at all, but I'm more than happy to help them feel comfortable. I always tell them, welcome, because I know it's a very difficult time for them. I know they're maybe probably hanging on by a very thin thread, just coming in there, and they've been waiting desperately for this day to get in front of the judge. So I try to help make them feel at ease and let them know that there is support. The Family Self-Help Center is there to help them. If they do have any additional questions that I'm not able to give them because I'm a neutral, I'm not allowed to give legal advice. I'm out of time.
JP Edwards, Armed Forces Chamber. So basically going with my colleague, Mr. Carlton says, they're in family court. So it's going to be one of the worst days of their lives for somebody.
100%.
Walking in the building, their heart rate's going to go up automatically. That being said, how do you manage professionalism and order when litigants are highly emotional or confrontational?
I'm very good at that. That's one of the areas that I shine. When I and my staff come to work, we're going to work just like everybody else, right? We're going to work and we're, dealing with our lives. But if we're telling a joke about something or something that we saw on TV whatever, just like everybody does in their normal work environment. When that door opens and those people come in, I try to shut it down. Well, for myself personally, I shut it down. And acknowledge, recognize, like I said, that these people are going through a lot. They know that I have the authority to impact their lives in a very, very specific and personal way. And so I'm very cognizant of that. I'm very sensitive to that. I think that's one of the reasons why I wanted to be a family court judge in the first place, because I felt like a lot of the judges might not have that ability to do that, recognize what they're going through, and realize that the court needs to be compassionate from where they are. We're very, very different than what's going on at the other courthouse for that very reason. Because something that normally might be a very simple transaction between two people gets all kinds of messed up and clouded because of the emotional history between the two people, and they're hard. It's very difficult for them to separate that.
Frank Friends, Veterans in Politics. So over the last decade, we've seen some really weird court cases involving trans youth where parents will try to take a child out of the custody of another parent because they won't transition them. WPATH just did a 12-year study that states that if you leave the child alone, they will grow out of it by the time they're 18 and just become a gay, bisexual adult, or just normal and not even be trans. However, if you intervene with medical procedures such as puberty blockers, actually letting them transition their name, and things like that, you increase this child's suicide rate to 40 to 44%. Knowing this, as a society as we do now, and WPATH is a pro-trans organization that prove their own studies the wrong way, how will you go about having one of these difficult cases put in front of you where you know that it's no longer in the best interest of the child because it will increase the suicide rate if you have these medical interventions instead of letting the child just go through puberty and overcome it themselves?
You're a statistics guy. I have not encountered that in my courtroom. I know it's being litigated across the country. I would hear all of the evidence that they're presenting to me. If you're asking for my personal opinion, which sometimes I do have to separate from what the law tells me to do, but if they don't give me the evidence, the evidence to support their position that they want the court to order the transition, then I have to deny it. I mean, because they have to prove to me that it is in the best interest of the child. And I think that would be a very high standard for them to prove. Again, it's preponderance of the evidence. 51% more likely than not that it's in the best interest of the children. But I'd have to have medical evidence. I'd have to have probably psychological evidence. I don't know. I don't know what evidence I would need, but I would have to rely on the evidence that they present to me.
Bill Carnes, Nevada Veterans Association. So, Judge, all sworn statements, submissions, and evidence are essentially seen as being submitted under the penalty of perjury. It needs to be true and factual. Considering that many of those things in these various cases come out to not be factual, they turn out to be essentially mudslinging and false accusations. Have you ever considered or actually gone through with holding someone who has submitted many, many false things under the penalty of perjury?
100%.
Can you cite examples?
When you said holding them to the penalty of perjury, I'm not a criminal court, but I definitely make findings one way or the other, whether or not this person is credible or whether or not they're not credible. And I often see people who are not credible. I start from a point of, I assume, positive intent until they prove me wrong. So if I happen to know one thing is true and they say something completely different, I try to determine whether or not there's any wiggle room, like maybe there's a little bit of room for misinterpretation between what that person is saying and my understanding. But often, sometimes, I shouldn't say often, but it does happen where people, they will come in and flat out lie because they're going after their children or whatever. They're fighting like what they believe like hell for their children. And so, yeah, I expect that they're going to tell me the truth. Now, I don't throw them in jail for that, if that's what you're talking about. I'm not a criminal attorney, but I will state on the record whether or not that person is lying and misrepresenting the truth. And then, that would leave it to the proper authorities to try and prosecute them for the penalty of perjury if necessary.
Mike McDonald, VIPI. Judge, have you seen the first question? Have you seen the documentary Divorce Court? Okay, and why I say that is there's a custody evaluator in there that was making recommendations to the judge that was a cross-dressing person that had mental issues that was giving recommendations to the court. How much deference do you give to custody evaluators and reunification therapists and things like that? And how do you make up your own mind as to the equality and having joint custody and whatnot? Thank you.
In the context of the person making a custody evaluator or a therapist or those other people, I contemplate that in the context of all of the evidence that I have, because I have to do that. If I flat out disagree with them because something that they have said is in direct contradiction to some other evidence that I have, then I'm not going to pay attention to that as much. But I have to, again, weigh all of the evidence. It's like bricks of evidence. Some bricks weigh more than others. And I just have to take that into stride with everything else. I don't rubber stamp what they say, if that's what you're asking. I do not. I'm the decision maker, not them. It's my job.
Bradford Carlson, Armed Forces Chamber. I'd like to bounce off the last two questions just a little bit, because in my practice before, a significant portion of my clients were family law clients. And I found that they lied to me significantly more than my criminal clients would for some reason. It was really weird. I loved my criminal clients. My family law clients lied about everything. And so when they come into court, how do you evaluate what the truth is? How do you determine whether this is the fact or this is the fact? I know you're balancing the evidence, but exactly how do you do that?
One thing that I rely on heavily and is whether or not people are willing to admit negative aspects of themselves. For example, if I have evidence of text messages or communications between them, things that they've said or things that they've done, and then they come into court and tell me, no, I never said that, or, well, that's not what I meant. No, then I am automatically not believing them. I believe in accountability. I believe if they tell me, yeah, Judge, I did that. That was a very poor choice on my part. Now they're establishing credibility with me because we're all human and we all do dumb things. And it's amazing to me how both of these parents do dumb things and they want me to say that that parent is evil, but this parent is the angel. I'm like, wait a minute, you put yourself in that set of circumstances. You know, the way you responded was maybe not very good. Maybe you should have made some different choices, but it's when people hold themselves accountable that builds credibility with me. And they don't know that. They think that I only want to hear, unicorns and rainbows. I'm the best. I'm the greatest. I'm super parent and I do this and I do that. And this other parent is horrible and they do. No, it's when they say, yeah, I messed up, but this is what I'm doing to fix it. Because the law doesn't require parents to be perfect, thank God. We don't have to be perfect. And we're all imperfect. I wish I had more time to answer some of these.
J.P. Edwards, Armed Forces Chamber. J.P. Edwards, Armed Forces Chamber. What reforms, if any, do you believe are needed in the family court system?
What reforms? This is going to be unpopular. This is my personal opinion now, okay? It's my job to interpret the law. My personal opinion is sometimes the law and lawyers prolong the process unnecessarily and extend the process because of following certain rules of evidence. I wish that the law sometimes would just allow me to talk to these people one-on-one, find out what's going on, tell me what's going on, and why do you think what you think? Why are you asking for what you're asking? Why is this other person unfit, in your opinion? What have they done? Do they have a history of that? But the law doesn't allow me to do that, especially with lawyers. I have to sit there and be a neutral, and I have to let them ask all the questions when not necessarily. They may not be asking the questions that I want to hear from. So we have to follow certain procedures, rules of evidence, and sometimes in family court, I just want to get these people in and out. I don't want to have a whole bunch of hearings, that cost a ton of money, and the emotional price I'm aware of is tremendous, and I wish that there was something that I could do about that, but I have to follow the law, and it's very frustrating for me. It's very frustrating for the litigants, and it feels unfair to them, and a lot of times it is.
Thank you, Judge. So now with these red flag laws coming up, people can come in there, be fictitious litigants, lie to you, things like that, report false TPOs, and try to take away somebody's Second Amendment constitutional right to carry a firearm. If you had a case in front of you where you found out that the person was falsely accusing the other person of abuse, falsely filing TPOs, constantly, trying to take their Second Amendment right, where would you stand on standing up for the other litigants' Second Amendment right?
When I went to law school, the professor would always answer every single question with "it depends," and that's so unsatisfactory. It was so frustrating then, and it's frustrating now. I'm aware of the Second Amendment right to carry, bear arms, and it's the law. Therefore, I support it. And unless there's some really, really good reasons to do otherwise, I'm going to follow the law. For example, if I have a litigant who uses their who is not say they have a proclivity for shooting, I don't know, animals, in the street, or being very reckless or something, maybe that would be a set of circumstances where I need to step in and do something about it. But typically, I have not encountered that in my courtroom. I would follow the law unless the facts and circumstances in that particular incident indicates that I should do something different for the safety and well-being of the children, the parties.
Judge, the first question I asked had to do with judicial authority as outlined in the Nevada Constitution. And you started with the federal defining it and bringing it down, which is great. And by the time ran out, we were almost there. So I'm going to ask you to kind of pick up from there. It's Article 6 of the Nevada Constitution that outlines the judicial structure in Nevada. Have you? I'm going to ask if you've read that part of the Nevada Constitution.
I have. It's been a very long time.
Let me carry on from there. And in there, can you describe your understanding the vesting of the judicial power within the state and within the courts, which Article 6 established?
So the Constitution gives the authority, establishes the authority for the courts to exist, and then and to make their own processes, like getting direction from the legislature. I'm sorry, it has been a very long time since I read it. I'm not sure that I could answer that in a vacuum right now without taking another look at it and being able to interpret it for you, quite frankly.
I designed my questions to be challenging.
I picked up on that, sir. I picked up on that.
Michael McDonald, VIPI. Judge, I have a really pressing question about veterans. There's a lot of veterans that go through the courts, and they are often seen to have PTSD, or they're known as have violence or killer, and their custody rights are taken away from them. What would you do to weigh that? Whether a veteran gets their children or not, and there should be the standard of joint custody, but what signs are you looking for? What things would you do to make sure that equality, or that veteran is able to see their kids, and that fundamental constitutional right is actually followed?
I would definitely want to hear from that veteran, talk to that veteran on the witness stand in the evidentiary hearing trial context, and talk to them about that extensively. Tell me what, that, if they have been diagnosed with PTSD, I would ask them what happened, what were the circumstances that prompted that? What kinds of things trigger you, to have a response to that? And how does that interplay with interaction with your children? Because I'm starting at, like I said, joint physical custody. And unless the other side can build a case to show me that veteran can't ensure the safety and the well-being of the child, that veteran is going to get joint physical custody. But I need the veteran to tell me how do they handle that? Have they taken any, classes or training or some kind of counseling or something to manage their PTSD, what it is that they would do if a set of circumstances arises? I would just talk to them and find out what can they do? What kind of procedural safeguards are they going to put in place to ensure the safety of the child. But again, the other parent has to raise all that. They have to prove by a preponderance of the evidence that there is a problem with this veteran. And if they don't, that veteran gets joint physical custody.
Bradford Carlson, Armed Forces Chamber. So you've mentioned several times in your answers that you would follow the law. Even if your personal opinion was a little different, you would follow the law. Are there any circumstances where you would write an opinion that may not be following the law because you don't feel that the law is correct and then risk appeal?
I'm sure that has happened. I can't think of an example at this moment. Let me try. I do have to set my personal preference, my personal feelings aside when the law conflicts with them. I can't think of anything right now. I know it exists, but no, I have to. Well, I can't think of any examples right now, but yes, I put my personal feelings, opinions aside and act in the best interest of the children and follow the law. I look at the factors, and if there's something that I happen to know that is contrary to the factors, I'm allowed to include that fact. This is just so generic, and I wish I could think of a really good example. I can't think of an example, but I'm going to think of it as soon as I walk out of here. I'm sorry.
J.P. Edwards, Armed Forces Chamber. So we've established the fact of how you run your court, how you make your decisions, how you separate your personal feelings from the law, how you feel about certain subjects pertaining to parental rights in custody. My question is, tell me something about Michele Mercer that we don't know that helps you be a better judge on and off the court or on and off the bench.
Thank you. I've been preparing for this job my whole life. And it's where I'm supposed to be. I didn't grow up knowing that I wanted to be a lawyer, and I didn't grow up knowing that I wanted to be a judge. I feel like along the way, I gained experiences and education that led me where I am because I'm curious. And I am a judge, but I'm not judgmental, which to me seems in contradiction to one another. What I mean by that is, maybe somebody disciplines their children in a manner that I personally wouldn't do. Maybe that's a good example of where my personal opinions differ from the law. The law allows corporal punishment, actually. Under strict conditions, you don't leave marks. I mean, but my personal opinion is it's really not necessary, because you can just speak, talk to the people, and I don't disagree with corporal punishment when the children are very young, necessarily, but I will certainly not fault somebody. And I'm talking about corporal punishment. I'm talking about maybe when they're teenagers, okay? Not necessarily when they're smaller, because with teenagers, you can take away privileges and, that's really coming across not as I intended.
All right, Judge. Well, you can relax a little because this is going to be the last question to have you on the hot seat. So let's say you have a litigant and or an attorney who comes forth to you and it's not substantiated. It's 100% proven that they keep filing false things that the other side can completely dispute and show you 100% in the evidence what they're saying is not true. Here's video, here's text, here's everything. And they continuously file these false allegations, whether it's a pro se or an attorney. At what point do you as a judge step in and have enough of that on your case and just side with the other side that's telling the truth?
Personally, my threshold would be very low. I would not put up with that personally, but the law tells me that I have certain factors that I have to follow. There was to determine whether or not somebody's vexatious and they're just trying to harass the other party. They're just trying to hurt them. And I have instructed them or entered an order that prohibits them from filing anything unless they submit it to me first, and I determine whether or not there's even an ounce of credibility to that, those allegations, and then I would allow them to file it. But so far, when I have stopped it and said, no, you're not going to file any of these false, ridiculous allegations anymore, they haven't actually come back and tried to file anything again. So it works. At what point? I don't know. It would, again, depend on the set of circumstances. It depends. I know. I hate that. I really do. It's unsatisfactory.
Okay, Judge, give us 1 minute as to where people can reach you and why you believe you're the best person for this position.
Well, thank you all. Thank you so much for being here, and I really appreciate it. I know you have other places you could be too, and but what you're doing is very important because you're doing the work for a lot of voters who aren't doing the work necessarily, and they're relying on you to make an educated decision on which candidate should be elected. In my race, I have one opponent, and the way y'all format your panel discussions here, typically you have all of the candidates here. Well, as you can see, my opponent is not here. I care. I am here. I will be here. And I do the right thing. I do the right thing all of the time. And I care very much about people. I'm very much involved in, not involved, I'm very much concerned about what's going on in their lives. I take a look at every detail of the case and make the best decision I have with the information that I have. And I'm out of time.
Thank you for your time, Your Honor. Panel members, thank you. Facebook, thank you. And that will conclude this interview.